ఇంటరాక్షన్ సెషన్ ఉంటుంది. ఆ సందర్భంలో మీరు 1 by 1 ఒక డిసిప్లిన్ ప్రకారం మన క్లాసెస్ ఏ రకంగా పద్ధతిగా వెళ్తున్నాయో అదే రకంగా ఈరోజు కూడా అదే సైలెన్స్ మెయింటైన్ చేస్తూ హ్యాండ్ రైజ్ చేస్తూ 1 by 1 రిపీటెడ్ గా ఆల్రెడీ ఒక క్వశ్చన్ సంబంధించి ఆన్సర్ వచ్చినట్లయితే మళ్ళీ దాన్ని అడగకుండా వేరే క్వశ్చన్స్ అడిగి దాదాపు అందరికీ అవకాశం ఇచ్చే ప్రయత్నం చేస్తారని చెప్పి మేము ఎక్స్పెక్ట్ చేస్తున్నాం. సార్
థ్యాంక్ యూ కృష్ణ రెడ్డి గారు. ఐఎమ్ రియలీ హ్యాపీ టుడే to give this lecture on behalf of Indian Legal Professional Association of Telangana. In fact, last time when Krishna Reddy requested me to give a lecture on Hindu law, I was little not prepared at that time because I was having some other program in some other my personal work. So I requested him to give next week. So this time I have accepted and I have now taken up this. Executing a will, this is what is called testate. Without execution of will, dying without execution of will is intestate. Then whether these two words, first let us understand Hindu succession, then law, act nothing but law. Law made by the parliament. Act enacted by the parliament. Parliament, as I said, is general will affected throughout the country through the representative sitting in the parliament and making the law accepted by the president. It's now law. Now, this Hindu again, property is concerned. One is joint family and it's separate property. Ancestral property, separate property. Joint family again is a bigger concept. Here one must understand because that's Krishna Reddy referred. Many of the concepts has become complicated. Hindu law is always a complicated subject. Once we understand the history of this, maybe little confusion will be little avoided. Now, as I said, if there is no partition and the property continue to be the joint from generations to generation, from 2-3 generations, that property which is inherited by the grandfather and then father is concerned. Once father, can he will it away? Can he will it away through his testament? The ancestral property which is not acquired by him, by all the members together contributed to the growth of this joint family property, like a corporation. Corporations, members change. But apart from that, it will also increase, it will also acquire certain new properties. Out of the old equity share stock market, you just see the equity shares, each one will contribute. And then they are also acquiring a company property itself. Company property again divided among all the shareholders, not one particular. Can anybody take it away? Unless it is divided into, it becomes a company property. Like that, this property is concerned, it is a joint family property until it is divided. Divided means partitioned. Joint family, that's why we have a member of joint family again, as I said, these are all consisting of female members as well as male members. These are all what is called hairs. Hairs are different. Maybe 10 hairs, both female as well as male hairs. Daughter, sons, grandsons, granddaughters, their wives, as well as the mother. They're all members as a heirs. They are right to maintenance, right to their marriages, expenses maintained, deducted out of the joint earnings. But do they have the right to partition, right to share in the joint family property as equal to that of any other person? No, that is where exactly. These are all what is called co-parcelary. Because it's only the succession through male line, not through female. Female, as I said, she becomes, after marriage, she becomes separate. If she becomes a widow, then widow maintenance is there. If she is unmarried, these are joint family, the people will have to maintain. If they are old age, again they have to maintain. Even if they have a separate property, that has to be maintained by him or her. These are all things. But after this, there is no change. 1956. That was as it is codified. Whatever that is there by the reforms introduced by the British, that the British himself, they themselves have given the right to female members out of the self-acquired property, but they touch the co-personal property, joint family. So that was incorporated in 1956 Act, because these two laws, Hindu Law Inheritance Amendment Act 1929, by which the female members are also introduced as class 1 heirs. These are all distributed class 1 heirs. You must be understanding the section 8 as well as section 15, female as well as male. Succession, right to succeed. It will be class 1 heirs. If there are no class 1 heirs, then class 2 heirs. If there are no class 2 heirs, then maybe government will become the property. Then section 29 or 30, 29 is there. If nobody is there here, then property will go to the government. These are all things. Then this section 6 is concerned, is the most crucial section in the Hindu Succession Act referring to joint family property. Joint family ancestral property. Because this is the area where many of the judgments have been faltering interpretation in each facts of case. Because when a right to partition, right to division, then disruption of the joint family, then again merger, blending. Suppose some member of the family after dividing himself, he wants again come back. Then can all the family disrupts? Then one of the family members wants to go out, all the family disrupts. When everything is disrupted, then it's separate. It becomes separate property. A separate property includes joint family property. These are all matters where several judgments in each factual narration. We need not go into the factual each case. So it's necessary for our understanding in a particular case how to apply these principles to the actual case. But let us understand the principle. Principle is the joint family male line is called co-personary. Joint family male and female line together constituted joint family property. Once the male line co-personary can ask the partition at any time. maybe after he becoming a major. But his right is acquired through birth. Even if a person unborn while in womb, if turned out to be a male, then his right as a co-person will still be there if it is not partial. Then a survivorship. Because survivorship, what is meant by survivorship? Survivor means whoever is surviving at the time of partition. Time is important. Understand that. Time. When every member of the co-personality has got a right to ask for partition of the property, and that is the time. By that time, whatever property is divided, suppose if there is already a person who is in womb, but meanwhile, when he is in womb, already conception has taken place, partition has taken place, then what happens to his right? Under the law, he has got a right. He is also by birth, he gets the right. By birth means by conception itself is birth. Then he can ask for repartition. Can he ask for? He can ask. There are some cases where even unborn child, after becoming major, he also files. Then the whole thing, sales or purchase, they have set aside. This is all for principle, the rights of a person, both born as well as unborn, of a male line, in a ancestral property is concerned. The other members is concerned, they are only right to maintenance, limited rights. Suppose if unmarried daughters are there, some widows are there, mother is there, the property is divided, then what happened to the right of these people? Then there is called the Hindu Adoption and Maintenance Act. They have got right against all the members. They have got a duty to protect them, maintain them. Till there, either remarriage or till their death. So, now that section 6 is concerned. Then section 8 is concerned. This is separate property. But this is also, if he has not taken any funds from the joint family. As I said, if anybody comes to say that this property is nothing but separate property, but is out of the giant family nucleus funds, these are all cases where any number of cases on this point, and many times courts have held that it cannot be treated as separate property and you are not discharged your right to prove. Discharge your obligation to prove that. Burden to prove that. So if the burden is not proved, they will be treated as joint family. If the burden is proved, they will become separate property. Separate property means then what is the people who have a right? These are all again intestate, testate. If the testate is self-acquired property, the father or any person who acquires, he has got a right to will away his property as he likes. Provided if there are unmarried below 18 years, he has got a duty to maintain them till they get the 18 years. That's again under the Hindu marriage, Hindu adoption, Hindu adoption, what is that? Maintenance Act. They have got right to maintenance. So, this separate family, all are equal. There is no male, female. There is no difference between male and female. Again, the father, if he is separate property, not part of the joint family property. And if he dies, his only succession opens only on the death of the father without any will. Then both mother, brothers, daughters are entitled equal share. The question arises, suppose a daughter has got some predeceased sons are also there. Predeceased sons, he is also entitled. His sons will be entitled. Son's daughter will be entitled. Because he is deemed to be a son. If he is left living behind his 5 or other sons. Suppose if there are 4 sons, out of us 2 sons died, or 1 daughter died, but their children are there, they are entitled for equal share. Among them, as per capita, this is another important. A share equal with that of all other members. But among the branch is concerned, that is a son, predeceased son, and he has got 3-4 children, then for them is concerned, they are called per stripe. They get per capita. Then until they divided, they should ask for their own share in this property which is devolved on the deceased son or even son also. Because that becomes a property for them, ancestral property. They can ask for what? This is separate property. They are not entitled. Suppose if there is a father, he has got both ancestral property as well as separate property. They are all clubbed together. Let us say 100 rupees here, 1000 rupees here. Total together, his share is now after the partition of the joint family 1100. This 1100 will become the corpus for so far as the other members are concerned. They have to divide. Suppose 4 major sons, daughters are there. Then 4 divided by 1100. 1100 divided by 4. Each one will get. Out of that again, the other people, their own children, they'll take their own equal. But that is not by, they cannot, it's undivided it comes. This way, this concept of per capita and per strip. This again we come to under section 19 of the Act. Let us first let us complete this section 88. This is general succession of the male member. Again, that is father only. Suppose there is also, these are all class 1 heirs. Then if the class 1 heirs are not, they are all equally entitled. But the same thing applies to the female? No. Female property is a Stridhana property. Now, of course, after the 2005 amendment, I will come to that later. What happens, what difference does it make from point of view of this general distribution of property, even among the female as well as male? This Stridhana property is concerned because Stridhana maybe their mother has given, the woman at the time of marriage, several gifts have come through their maternal side or some other people who have given. Or through her own self-acquired properties may be there, through her own learning and other contribution to the society. Then again, it's a question of self-acquired and her own property which has devolved to her through their maternal property. Many times what happens at the time of marriage, the mother side, gifts, several gifts will come through lands, through money, jewelry, other things. Then that question comes. This is a separate evolution. So that property is concerned, if there is a husband, he will get. Our children, sons, son will not get, daughter will get, son's daughter, but others won't get. Then it will have, if they are not there, they will be written back to their own maternal side, through whom that gift has come. But in the male side, it's not there. It's coming from there. It's not coming from some other force. This difference one has to understand. This female inheritance and succession and the male succession. This 2005 Act also amends the same thing in the same line. Now I have explained so far as legal heirs are broader in nature, but co-personaries are smaller in number. If there is only one co-partner, then it becomes his self-acquired property. It's like his own. But now after the amendment, it doesn't, because if the sister is there, she will also get the right, provided other conditions will be there under the 2005 Act. So now come to the section 19 is nothing but the same thing. I have explained this per capita, per strip, tenants, and then tenants in common, joint tenants. This is also one of the cases where tenants in common means on death of the father, they get the equal share. They become owners. But undivided share per capita. But position is concerned, they remain joint. Ownership divided, position remained the same thing. You can also will it away, your own property. Person who has purchased it, he steps into the shoes of your. So, but is it applicable in the case of joint family ancestral property? Because their survivorship is there. But before his death, can he will away his share? He can, under section 30. That is section 30, where testament is concerned. He can will it away. The other person will step into the shoes. But if he doesn't will, then survivorship will come. But he also has no right to ask for partition. The other person, and ask for partition and separate position only through, he can ask for division. That provision, many people also exercise that right. But at the time of sale or other their properties within the joint family, the preferential right is given to the next immediate person in the either sons or daughters. And if they don't take, then the position of other person selling to third persons will be there. These are all provisions. They are not that important in the point of view of understanding this Hindu law. Succession Act. So, daughters have a right to equal share on par with son in separate property under Section 8 of the father. If a joint family is broken down, his share is also there given to the father, that also becomes his separate property. The daughter is entitled to the share which has acquired through joint family division and part of the separate property together will become her right to equal share. If it is not divided, then she has no right to ask for any, that portion is concerned. Then after the success, now let us come to this. Then what made the necessity to bring about the changes towards the reform, like right to equal right to female members, daughters. First amendment, I think this type of reform, granting same equal status to that of a son, because there can't be any discrimination. This is a movement towards equality under Article 14 of the Constitution, not only here, throughout the world. Human rights, gender equality, because they are all contributing to the family in various ways. They are also asked for right to equality. Of course, what is its implication is a different thing, but equality towards gender equality is there. So N.T. Ramarao has introduced the first 1984 and 85 Section 29 amendment, as well as that is conferring them equal status of a co-personary on par with the son with effect from the date of amendment. The marriages, the daughter who has married before that date, they were excluded from that, because that is a prospective. Many of these British also reforms are also prospective, because otherwise retrospective means it creates a lot of confusion. What happens to the already settled positions? People must have settled through partition and to again sales, purchases, gifts, so many other ways. Some people must have incurred several debts on the basis of that, earned profits. Now all that cannot be reviewed and reopened things. Unfortunately, 2005, the latest judgment, unmindful of that, has given the judgment. I will come to that. Now, followed that, Tamil Nadu has brought, Karnataka has brought, several other states have also brought amendments conferring the same status that of those also. Then, during this period, 1985 and thereafter, either under Section 6 or under Section separate, Section 29A, B, C, A, 6A, 6A, these are all several states. Then, Centre has noted all this. And a pressure was also there, because modern society, this inequality of gender inequality, which is prohibited under the Article 14 and 15, and recognizing the need for making them equal on par with the sons, because for father is concerned, son and daughter is the same thing. From the legal point of view, from the tradition point of view, this inequities has come, maybe for expediency, because once she married, she goes out, then her contribution to this aspect is still missing, as unexplainable, because you are right only through your contribution to your work into the family. Once married, What is your contribution to the original? These are all questions which still may have to be, because these are all equality and inequality. How to compromise this, balancing these things? These are all aspects which maybe future generations will accept, will render that. Because once small families are there, these questions may not arise. But now, 2005, the center has brought about this Amendment Act. In the amendment, while treating them as equal, all words it says from this today onward, all that. But he has introduced one word explanation. Only if it is already partitioned, disposed of, this will not applicable by the time it has from 2004, the date on which the bill was proposed. Act was made in 2005, but it has come from 2004. But what extent is the retrospective effect is concerned? From the date of already it's mentioned. It's by that time, if it is disposed of, otherwise alienated or disposed of, other things. But explanation, what is partitioned? Partitioned is also there. But in explanation, what is said? Partitioned by registered deed. That has brought a lot of confusion. I think legislature may in the future they may take note of confusion raised by this, because in the 2000 state amendments, no such condition of by registered deed, because many of the families in the rural India, all over the India, they even not even write before the elders or with the family members. They divide the properties by meets and bounds and they accept it. If there is only when there is a conflict between the members with respect to some things, then they will have to write down. And in most cases, they go to some cases they go to court. Otherwise, they have to register. In many cases, it doesn't happen. It go for in the maintenance of official records also. Generally, they go by the legal heads and partition reported to the revenue authorities. They make mutations. Registered deed is not even insisted. I think though it's there. Even in the 1971 Revenue Records Entries Act, 1971, there also generally the presumption is in a case where a property valuing more than 100 rupees, it requires to be registered. Because this is only a joint family property, it's not transfer, it's only recognizing the earlier rights. Partition. There is no transfer here. There is only mutation from father to sons, which each of them have got right. But suppose if one family member, they transfer to other family member or give up their right to property in that joint family in favor of so and so, maybe that requires, it's involving transfer and then requires registration, and that may have to be, because it is in compliance with the registration and the transfer of property act. In all other cases, there is no transfer at all. It's only recognizing the pre-existing rights. But still, by introducing that express words by way of registered partition deed, this confusion has come. Because all that, because these 3-4 judgments, they said that the Dhanamma case, as well as Prakash and some other 2018 judgments, they said this is succession opens when the father dies. And by that time, if there is a living daughter, then she is entitled. Suppose by that time, daughter already dead, there is no living daughter, question of 4. So, if the father already dead before that date, succession opens before that date, so by that time, rights have become mutated in favor of other members, then the daughter after the event has not acquired any new right. Rights have already been crystallized before that. These are all decisions taken in that 3 before the judgments. But there also the question of registration, registered sale, registered deed. Disposed of, that was again a confusion point. But they have again said it's a legislative intent by settled principles of interpretation of law, not as a retrospective but always prospective. Succession which were already opened before that date cannot be reopened. It will cause innumerable sort of problems. Maybe that judges have noted that and they said it's only prospective. But unfortunately, without unmindful of the consequences of the consequence of taking a view of retrospective effect. By taking the express words partition, they want to give a meaning to the partition, registered partition. In all cases where partition is not registered, then what happens? It has to be reopened from 1950s. People must have sold several things. They have paid the debts. Now can the Act says same rights and liabilities of the joint family property. Rights and liabilities with respect to the death of that family at the succession opened, retrospectively is about 30 years back. How do you determine that? Now, this view is taken in Vinit Sharma case, that is 2009 SCC page 1, Vinit Sharma case. This is Justice Arun Mishra. He just before his retirement, he has pronounced this judgment. Maybe he wanted to give full effect for gender equality. But giving full effect gender equality, good. It's a law is a general will of the people. If your particular interpretation will cause so much hardship to general people by reopening the whole settled family, whole transactions, litigations, family unrest. Maybe sometimes legislature is competent to enact retrospectively provided a particular identified mischief is there and cure that only. Limited effect so as not to cause general inequality, disturbance of the peace, society. These 3 judgments which they said prospective, there was no hue and cry. Maybe even there also some daughters may feel that we are deprived of. But from the point of view of 19 before Act, this is only new right conferred. New right with retrospective effect means rights are always, substantive rights are always to be with prospective only. Procedural rights you can ask for retrospective because it's only procedure. These aspects But of course, the learned judges in that case also have noticed that this is caused lot of disturbance. But they said, clarified it, saying if there is a genuine partition and it is proved, then they are not entitled. Then what is genuine, what is not genuine? Suppose if a married woman, in a particular case in our which we have encountered, a person who has long time married, about 4 decades back, she files a case, I am entitled for a share in property. And the brothers have done injustice to her. And the court refused to interfere. Yes, she is entitled to ask for. It's ultimately, it may be civil courts decide. But you just see the inspiration which it is giving, the litigation which is speculative litigation inspired by this interpretation. And it will, how much strife it will bring about in all families. Because it's a matter of not one or two, one or community, it's an entire society is now filled with family strifes. Maybe some people may refuse out of their own love of peace in the family. But suppose if they are so self-centered, no, I want to exercise my right, then what happens? Every family will be in the litigation, in the unrest, and the whole India will be under unrest. I'm only, maybe it's an exaggeration, maybe, but the effect of it. The parliament thought about it by wording that partition deed, registered partition deed. Maybe draftsmen, out of oversight, out of hastiness, we cannot presume that, but still we presume that they have done after deliberation, after study, but still human errors are always there. But the court will have to mitigate that. Instead of mitigating that, as I said, sometimes judgments, instead of mitigating the problem towards the general will of the public, it goes to the particular will. It creates a lot of disturbance. That's why I started beginning itself. General will and the particular will. If you want to give effect to full, it's only your wish that it should be given full effect to. There is an ambiguity. There are certain provisions which says to prospective from the date commencement, after commencement, that this word is inconsistent with that. I want to give effect to full effect to this. Maybe sitting as a judge, I may feel, because it's only my own personal views sometimes place. I have a thinking, yes, daughters should be given full right. This is my particular view. Suppose if I rub it on the general will, then there will be a strife. This is not a general will. Then how to determine this general will and a particular will? Out of strife, litigation. It brings about a lot of litigation. Then there is a sort of, this is only an index of not consistent with the general will. Because how to measure general will? Its effect upon the general will, particular will. So this way, as I said, people who are inspired by this judgment are making claims from 1950s without respect to limitation, without respect to things, saying so many allegations, other things. No. This will lead to, as I said, If the law bends towards a particular section by bending the general will to give benefit to certain sections, then there will be a strike. This also will file in the political scenario here during 1952 onwards. Some political parties saying that you are giving too much appeasement towards certain sections and not reflecting general will. Some people will say these are all things which ultimately political changes will happen. They are not concerned about that. But it's a question of interpretation. We must always try to see that it reflects the general will of the people. Law is nothing but a general will of the people reflected through sovereign, through parliament, through president things. It's not prime minister, it's not chief justice, or it's not a speaker. Because under the constitutional law, no particular person acting the monarchical, you just reflected through monarch, king. But in a democracy, the power is distributed under the constitution. Nobody is a particular sovereign. It's a giant sovereigns. Distribution of powers, separation of powers. No one person can claim I am a sovereign. The sovereignty lies only in the president. President is also a nominee of a public. So ultimately the public is the sovereign. Sovereign, general will is the general will of the public, reflected through president in the law made by the parliament. And the court will have to see that it's reflecting the general will. If you make a mistake, as I said, several wars have come in US, Red Scots case, equality among only whites and blacks. People disagree. Citizenship, only white citizens, Red Scot means the court has interpreted citizens means only whites. Blacks are chattels. They cannot be treated as equal. They have no right to citizenship. They have no right to participation. That has given to a lot of civil. Slaves have no mind. They are all slaves. They have no separate mind. They cannot act as citizens. In fact, they have also treated many of our Indians at that time like that. They have no mind. They are all slaves. They cannot govern themselves. Of course, in our even in our state also, some such comments were there. So things, politics will work out differently. But when question of courts are come, you should see that it's meant for. And we advocates, we must always keep that in mind as a professionals. And of course, political, that's why every profession should see that he should be true to his profession, true to the law, not ideology, no ideology. If you want to become an ideologist, if you want to become a politician, go out. Because you are not true to your oath taken under the constitution. You can become your own separate profession. Our profession is concerned. We should confine ourselves to the profession and see that the law is enforced and the law is reflected as general will of the people. And as far as general welfare of the people. That's why interpretation of also is this. So that is how things now I think it's too late. 8:30. Okay. I think I'll conclude my statement saying that ultimately, now I wanted to see these several judgments which you can also note. Latest judgments. There's the latest one. There is a Madras High Court judgment, which has also one of the contention raised is, as I said, general will, particular will. Which will prevail? in a case of repugnancy, it is always general will prevail. But in an all India context, when the several states are united into union and they have got separate rights under concurrent as well as a separate state list and union list, states are given the equal right, if not equal, but they also right to legislate in the concurrent list. This Hindu law is concerned within the concurrent list. They have introduced the separate amendments to the Hindu law. Section 6, that's NTR as well as Tamil Nadu, others, AP, Tamil Nadu, other amendments are there, conferring rights prospect to date, not the married daughters by that time. Now, this judgment has given retrospective effect, whether married or unmarried. What happens? Then Madras High Court is a case of conflict between the state and the central under Article 254(2), repugnancy. To the extent it's repugnant to the state, central, that stands repealed. Unless is again reserved to the president and separately taken. President has said to it as a separate, it's a separate provision which is within the locality. Now, after this, this issue was raised before the Madras High Court. Said what we have under state amendment, and this transaction took place before this, in between this 2004 and this is 1985 or some whatever it is that state central Tamil Nadu. Can it take away? Can it give the confer upon the right upon the married daughter? Now they said in view of the Vinit Sharma case, it has to be. It overrides central state. But in that case, that is AS number 687/2008 dated 11/5/2001. This is Hema Malini versus Palanis Malai. Palani Malai. This is a case where there was a registered partition deed. So, on the basis of the registered partition deed, she is not entitled for any share. Suppose the registered partition deed is not there, even the person who has come later, she could have claimed. Unfortunately, this word registered partition deed in that particular family happened, therefore she was denied. Otherwise, she would have got it. The same thing, this analogy is concerned, but they said retrospective in effect. Following this full Supreme Court judgment. Unless is a genuine partition or not, it has to be decided. Burden is upon the person who propounded that it's already registered, it's already partitioned. Now, person simply files a suit, the other person will have to struggle. Person now new type of maybe some changes. When a new change is sought to be brought about, reform has to be brought about. Some people will be affected. But this is not a small section of people, a whole society, whole families. Most of the families are Indian family, rural families are giant family. Most of them are unregistered partition deeds. But why this registered partition deed is in, we don't know. So that's why maybe they said the Supreme Court, they upheld the Supreme Court, they said retrospective, but she is not entitled because of that special. This is the as on today. Unless you prove that there is genuine, any daughter, even married daughter also can file, even at any point of time without limitation. these matters may have to be gone into at a later stage before the Supreme Court, as and when cases goes before them, may have to review, may have to take a different view, may have to even the legislature may take note of this. We don't know. May anything is possible. As on today, that is the stage of thing. So with this, I hope I have dealt elaborately about this subject. If you have any doubts,
thank you, sir.
questions, yeah.
Dear friends, if you have any doubts, please raise your hands. We will call as per protocol. Please raise your hands.
The language is no barrier. Please kindly mind, because ultimately we should understand Telugu, English, Hindi, anything problem లేదు. ఎందుకంటే మనకు ప్రాబ్లం అండర్స్టాండ్ చేసుకోవాలి. మనకి లాంగ్వేజ్ షుడ్ నాట్ బికమ్ ఏ బ్యారియర్ ఫర్ us to.
Sir, good evening, sir. My name is Praveen Kumar.
Yeah.
Sir, can you say?
మీరు హ్యాండ్ రైజ్ చేయమని చెప్పినాం కదా సార్.
Okay, sorry.
Okay.
Okay, you
Continue.
please carry.
Yeah.
Sir, how can we rectify the general will and particular will differences?
No, it is a political process.
Okay.
The general will and particular will, let us take state, center.
Okay.
Let us take within the state. There are different communities are here. A particular section of people, let us take trade unions or otherwise employers, take out the dominant position in the government and tilt the whole general will into their particular will. Then what happens? Then there will be a disturbance. Ultimately, it has to be rebalanced to the general will. But meanwhile, there will be a lot of strife. These are all political issue, political process. We are not concerned about the political process because that is our politicians and outside the political parties. But we are only understanding the process because as advocates, when we take as a profession, we must understand these processes because that understanding will enable us to avoid this unnecessary litigation, creating law interpretations of law, and will try to minimize it so as to maximize the national growth, welfare. That judges also, it is necessary for them to understand this.
Thank you, sir.
Yeah.
Next is I please ask you a question.
Yeah, please. No problem. No hesitation. Please ask any question. Any. I think I think better thing should have been to Telugu. Manam aithe manak language, mother tongue is Telugu. I think many other states they talk only in their mother tongues. Manam unnecessarily we are more concentrating on English. Yeah. Even otherwise, Ramana, Chief Justice, also telling people, please try to communicate.
Mr. G. SVS.
Yeah.
Unmute your mic and ask.
Yeah.
Unmute your mic and ask, please.
Sir, namaste, sir.
Namaste, Cheppandi.
Sir, general question, sir.
Yeah, Cheppandi.
Sir, as per interstate property, sir, father has two sons, sir.
Yeah.
One of the sons sold away property without partition.
Yeah.
So, will grandson has the right to get the property?
He can. So far as son is concerned, because
Sir.
once succession opens అయినప్పుడు,
Sir,
if it is an ancestral property,
sir,
now after this 2005 Amendment Act,
sir,
unless it is he can only sell his share.
but there is no partition, sir. Partition occurred between two.
పార్టిషన్ అయినప్పుడు కూడా అందులో సెక్షన్ 30 ఆఫ్ ది యాక్ట్,
Sir,
అందుకోసమే అక్కడ టెనెంట్స్ ఇన్ కామన్, జాయింట్ టెనెంట్స్,
sir,
యూనిటీ ఆఫ్ ఓనర్షిప్, యూనిటీ ఆఫ్ పొజిషన్.
Sir.
With unity of position and unity of ownership, ancestral property, joint family property.
Sir.
But that is broken down only when there is a partition.
Sir.
Partition అయినప్పుడు కూడా unity of ownership is concerned disrupted, but
Sir.
position remains the same thing. Unity of ownership disrupted, you become separate shareholder within the your own share is, suppose
Yes,
let us take 10 acres.
Yes, sir.
There are only five members, sons under అనుకుందాం.
Yes, sir.
Now let us call daughters are also there.
Sir.
Now 5 divided 10, 2. You can only sell your portion of 2 acres, but that is also the other person who comes there.
Sir.
He can only joint position only
Sir.
until it is divided by partition.
Sir.
Now that is section 30. The section 30 is to be noted.
Sir.
Shall I read section 30? Not necessary. You can just go through it.
Thank you, sir. Thank you.
There are several judgments to that effect. So that
Thank you,
aspect.
sir. Thank you, sir.
Yeah.
Advocate
iPhone.
Nero.
Hmm.
Sir, unmute your mic and ask questions, sir.
Sir, good evening, sir.
Good evening, Chapandi.
Sir, father's self-acquired property can file a partition suit by children, sir, or it should be valued or not, sir?
Not valid. Because
Not valid.
as long as it is self-acquired property, he has a right to will away, or he can sell, he can do anything, provided if the children are there unmarried, below 18 years, they have got a right to maintenance, that's all. And good education. Once he is attained majority, of course our families, most of the people are still with the father's parents, but that's not legally not required.
సోమాజీ కూడా నుంచి వెళ్తుంది.
Huh? So the children have no right to partition because they have no right. Their right.
Recently,
Yeah.
sir, recently Apex Court has given one judgment, sir. That's why I'm having some little bit doubt on.
No. That judgment you must have understood in a section 8 కింద వచ్చినప్పుడే section 8 కింద ఎప్పుడు వస్తుంది నేను చెప్పాను కదా section 8 కింద వచ్చినప్పుడు suppose if already joint family property is divided, let us take 100 acres joint family, 50 acres self-acquired property. I'm giving an example, an illustration. 100 family, 3 co-partners are there. Now we are not concerned about the present daughters. Suppose daughters are also added there. Suppose 2 daughters, 5 members, 20 acres each. That 20 acres, including father. Father will also get 20 acres. That 20 plus is 50, 70 acres he becomes. So again, 70 acres daughters have got the right. As every member of the family have got a right. But only when he dies. But also the 20 acres are concerned. 20 acres are concerned, they can file a separate suit for partition. Understand?
On father property.
Not against the father, but against the ancestral property which has fallen to his share. But suppose he dies, then all members become entitled to equal share. Not only male and female members. This is all section 8 కింద వస్తుంది. Section 8 is general rules of succession. This is section 6 is concerned special. It's not general. Similarly, section 15 of the female properties వచ్చినప్పుడు that general rules of distribute property of the female property. So your understanding that Supreme Court has given, I think maybe your factual narration, factual matrix you may not have rightly understood, or maybe it happens sometimes judges also. It's not all people are, many of judges come from our own community, isn't it? Suppose advocates have not rightly argued, or they have not listened to them. Make some mistakes. It's a continuous evolution. And that's why many of the judgments become review. They distinguish, followed, not followed, reversed. Why happens? Because making mistakes by judges also many times happens. Maybe it may be, but I do not think it's a mistake. It's only mistake of your understanding. I think this.
Okay, sir. Thank you, sir.
Right.
Suresh Babu Garu, please unmute your mic and ask questions, sir.
Sir, Suresh Babu, sir.
Sharad Babu. Sorry.
Yeah.
Sir, good evening, sir.
Good evening, Chappan.
I'm very happy to listen to your lecture, sir.
Yeah.
సార్ మీరు చెప్పిన కాన్సెప్ట్స్ అన్ని ఉండేటటువంటి ఏదైనా బుక్ ఒకటి మంచి బుక్ సజెస్ట్ చేయగలుగుతారు సార్? ఐదర్ ఇన్ ఇంగ్లీష్ ఆర్ తెలుగు సార్, ప్లీజ్.
No, concepts, this is all, it's not one book.
Sir.
It's a summing up of several books. It's what is now today lecture.
అవును సార్.
Let us call it the general will, particular will is concerned. This is a political concepts, political thinkers, which has enunciated by, as I said, Hobbes,
sir.
Then Rousseau, we hear Montesquieu, separation of powers, and he has observed so many sort of British legislative the British legal history. He has summed up some of the salient features of why this entire social life is going in an orderly evolutionary process. Then he summed up the process in which the king there, the commons, the lords means this aristocratic class, church, clergy. So far as the commons are concerned, the general common, as I said, Sudras here.
Yes, sir.
Kshatriyas are the people sitting there in the lords. But what happened? Shudriyas have become more powerful because they went out the world, they made money, they come back, they gathered power. Now when they come to their own country, they see these people are controlling them. They make the law. They revolted. Then king sometimes they sometimes joined with the commons, sometimes with the lords. He played politics. But still the question of granting of budget is concerned, because he wants to go wars, then he requires money. He comes back to parliament. Parliament again, commons are there. They are the money persons. They purchase with them. They don't grant. Lords they have no money. Their power is there. This imbalance which is now new situation has arisen, where commons have become powerful, lords have become less powerful, financially as well as other things. So this situation again brings about changes in the law. But this is not done through revolution, but through ordinary process. By evolution of law, they made laws. The king complied with the demands. Magna Carta we see, they granted liberties. French, they didn't grant. That's why there is a revolution, there is an execution. Even British also, there was a sort of revolt at the time of Cromwell. Cromwell executed the Charles I because he wanted to go against general will. That's all. These are all. That's why we see these several processes. These historical processes, legal processes, and this reflecting the general will of the people, thereby avoiding the social unrest. The Montesquieu has proposed that separation of powers. It's not just because of his mind he has come. He is only rationalizing the whole thing. It's also something like that only. You're only trying to, because here also, why in our Indian conditions, Aryavarta was there. Buddhism, we know that's a revolt against the Brahminical, this priestly class, and we have seen these routs. Unless ruling these princes, they observe this what is called the sacrifices and attend them. These are all nothing but again, this history has happened in Western countries also, but late. What happened there also? Church versus king. Church wanted at the time crusades. They said, no, we are the powerful. You are only unless I give you power, you can't act as a king.
Yes, sir.
Then there is a conflict between secular and spiritual. They wanted, no, you are after all material. I am a spiritual. Then what they said, then there is a conflict. Ultimately, the church is subordinated, and their puzzle power has overtaken the spiritual power. So that's how.
True, sir.
So, but there in French is a revolution. Several heads were rolled. Several terror has come. Then ultimately Napoleon has come and bring up the order. then by birth is replaced by merit. But later also he has become part of by birth. Then again he was divided, he was thrown out. These are all social processes. We have to understand that. This history, that's why every advocate, our professionals should not ignore the legal history as a general history. Fortunately, since I studied economics and our every day-to-day affairs are governed by the contracts. Contract is nothing but economics. Everybody will try to maximize their own interests. Contracts are formed out of general will of the two people. You, whatever you want, whatever I want, there should be a sort of contract. Exchange. These are all the economics terms. Terms are different, but ultimately same thing. In a national level, international level, it's a question of conventions, international conventions, international, agreements. Agreements again between countries, it's nothing but a general will of the two countries are multilateral. Now what we call multilateralism, bilateralism. What is the multilateralism? UNO is there. UNO is, these are all countries together, they act. These are all things, these are all nothing but contract of their own interests. General will again reflected between the countries. So general will has to be seen in that context. In the case of contracts, it's nothing but a consensus ad idem. But in the case of social classes, consensus with idem comes only out of the common interest. Okay. Separate interest, if you want to give separate interest, it's not a consensus ad idem. There will be a disturbance. Then there will be a violence. That's why British Constitution was one of the greatest example for human understanding of evolution process. Everybody must understand the British history, constitutional history, how the struggle between the Parliament, House of Commons, how it was evolved, how it has become powerful, while House of Lords, which was powerful, which has become less powerful, now it's almost abolished. The king also, one was a total unilateral monarch, House be titular. Now we adopted that constitution, our president is also titular, prime minister is too powerful. Now here is too much powerful, I think, because both executive and parliament is together in the same person because of the party. These are all some evils that has crept into our democracy also. It has got, unless we understand the whole history, historical processes, we cannot understand this and we cannot make a interpretation and judgments in the case of our own case to case, which ratio decision, as you said, is not only governed that particular case, but also governed other cases. That's why our profession, it's make the society in an orderly manner. We are more powerful, we are more responsible for that. You must understand that, you must be proud of that. By the noble profession, all over the even Roman Empire, advocates, lawyers were more respected and they were people who were governing the whole thing. Even the freedom history, people, lawyers. But now what's happening? We are forgetting the study of history, study of economics, study of multidisciplinary. People know. You are lessening yourself your own importance. You should do that. You have got plenty of time, teacher. Yes.
Mr. Sudarshan Venukuntla.
Thank you, sir. Blessed to hear you, sir. Thank you, sir.
థ్యాంక్ యూ సార్. నాకు లక్ష్మారెడ్డి సీనియర్ గారి నెంబర్ సభాముఖంగా పెట్టగలరా సార్? ఒక పర్సనల్ క్వశ్చన్ అడగాలి, చాలా పెద్దగా ఉంది, నాకు టైం
ఏం లేదు.
పాస్ ఇట్ ఆన్ సార్. ప్రగతిశ్రీ సార్, ప్రగతిశ్రీ.
Good evening, sir.
Yeah, please.
Sir, for example, A is the mother of B. She becomes a widow.
Yeah.
And after that remarries.
Yeah.
If B dies, can A succeed to the property as B's mother?
No, once the question arises on remarriage in this new act also, this widow rights prospects on once she becomes remarried, then the right to which it was there, it ceases to. That's all it was there in our Hindu law, Hindu Succession Act. It's only as long as she remains unmarried. Once she becomes married, then the right to property. But now after the remarriage also, under 2005 Act, there is a possibility, because what happens? She still remains a daughter. She still remains a daughter. Whether even marriage or remarriage, she still remains to be a daughter. I think you A, B, C. Better thing is you little factual narration may be given, because what you say is widow has got a daughter, and widow has remarried. Have I understood your question properly?
Yes, sir.
What is your widow has remarried?
Yes, sir.
She had her own children.
Yes, sir.
Now the children can claim the right.
No, sir. If the children dies, mother can succeed the property as this mother.
No, mother, whether marriage or remarriage, is still she's a daughter, isn't it?
Okay, sir.
This under the new 2005 Act, she continues to be a daughter. Suppose earlier she was the disability of a widow is now removed. She becomes married, but earlier also married, today also married. She continues to be the daughter. She can claim the right.
Okay.
Yeah.
Thank you, sir.
Yeah.
Thank you, sir. Dr. Mr. Donge, sir.
Very good. Thank you very much.
Sir, T.S. Donge, sir.
I should down my thing. Hello. Any other questions?
Sir, it seems no more questions.
Yeah. It's already answer mistake. Yeah.
Sir, one more question, sir.
Yeah.
Sir, one more question, sir.
Yeah, please.
తండ్రి వచ్చి ఇద్దరు కొడుకులు ఇద్దరు అమ్మాయిలు సార్.
ఇద్దరు కొడుకులు ఇద్దరు అమ్మాయిలు.
1985 సంవత్సరంలో తండ్రి గారు ఇంటెస్టేట్ గా చనిపోయారు సార్.
ఇంటెస్టేట్ చనిపోయినాడు.
చనిపోయారు. 1986లో ఒక అక్కకి, 1989లో ఒక చెల్లికి పెళ్లి చేశారు అన్నదమ్ములు ఇద్దరు.
ఓకే.
ఆఫ్టర్ 20 years అంటే 2021లో మొదటి అమ్మాయి ఆస్తిలో 1/4 షేర్ కావాలని సెక్షన్ 26 కింద కోర్టులో పిటిషన్ దాఖలు చేశారు.
ఓకే.
ఈ పిటిషన్ చెల్లిందా సార్?
Now 2005 Act ప్రకారము even at the stage of final decree stage లో ఉన్నప్పటికీ కూడా, if it is not partitioned, then she is entitled. Even under the old act also she is entitled. Now under the new act retrospectively she is definitely entitled under the new central act.
అంటే అమ్మాయికి లాంఛనాలు ఏదైతే ఇచ్చారో
అవి that will not change the law. That is one of the injustice meted out too, because I was pointing out these things also are creating some unrest among the people, families, because unjust burdening, balancing of interests in some persons who contribute to the family, persons who do not contribute but yet get the share. That problem is there. This law is in a way, we have to do that while arguing before the court. Our court will have to consider all this in mitigating these circumstances.
ఓకే సార్. సార్ దీంట్లో రెండవ డాక్టరు మా అన్నదమ్ములు మొత్తం మాకు చేశారు, మా తండ్రి గారు చనిపోయినా కూడా మంచి చెడ్లని మా అన్నదమ్ములు చేశారు కాబట్టి ఈ అమ్మాయి మా మొదటి అక్క వీళ్ళని ఇబ్బంది పెట్టడం కోసం ఇలాంటి దావా వేశారని చెప్పి తను ఆపోజిట్ గా తనకి పిటిషన్ దాఖలు చేసింది.
It doesn't work. She can give up her right. She can give up her right in favor of other members, but she cannot ask the other member to give up her right.
Okay. Thank you.
Right. Okay.
Any?
Yeah, thank you. Yeah.
Yes, sir. My question is that there are two words, inheritance and succession.
Yeah.
How effectively to use these both words, and is there any difference?
It's
And
actually
one more.
yeah. Yeah.
Yeah. Okay, sir. Next question I will ask later.
No, inheritance, succession is one and the same thing. The only thing is word succession opens on death of a person. On death of person. But in a case where joint family property is concerned, on birth. You just see the difference between inheritance and succession. In matter of ancestral as well as separate property. Now on birth you acquire the right. In a case of ancestral property, not death. But in a case of separate property, on death you acquire intestate only. Succession. Inheritance comes to you after death. But so far as in case of ancestral property is concerned, there also succession means it's only after death only, intestate, not testate. But I think for all practical purposes, under the Hindu Succession Act, the difference is only the Act has used the word succession. So we have to use the word succession only. Inheritance also you can use it synonymous.
Yes,
inheritance you can just simply say you have inherited by birth in ancestral property. But can you say you have inherited the property by birth? In case of father's separate property, you cannot say I have inherited. But in case of ancestral property, you can just say I inherited. That's some difference. You can make, I think, but for all practical purposes, it's only, but some sort of like, if you go to chemistry, both appear to be the same thing, but some element will be missing. Like in criminal offences, what is the difference between battery and the what that other scenario? Just little above that, hurt, grievous hurt. Some element will be missing. Something you have to understand that way only. But for all practical purposes, for our day-to-day things, it doesn't make any difference.
A.R. Shalini Garu, please ask question.
Yeah, one more question, sir.
Yeah.
Regarding limitations, please can you put a light on, short light?
Yeah, this is one of area where limitation issue also needs to be gone into in these matters. Because, but right is now created, 2005. And the knowledge of right our presumption in favor of knowledge, if it is taken, of the knowledge of our right under the Act, and she has not exercised that right for a period of 3 years. And she has allowed the people, or 12 years. In adverse position, it comes to 12 years. But in 2005, as and today, that question limitation, I think in case of immovable properties, may become redundant. But suppose, even in a case where people have a long time married, they have allowed the partition there. They never exercise their right to protest even at that time. They have acquiesced that. Then these questions with respect to that may be raised, may become the issue in a future cases. Because limitation has a very substantive thing to minimize this hurt to the general will. That is how court can go to the extent of exercising this aspect, limitation aspect, to minimize the damage already done to the general public, by virtue of this legislation, by virtue of that word registered partition deed. All this confusion arising only out of that word. Or otherwise the legislature itself will intervene and then remove that or qualify it. Because many of these state amendments, the word registered partition deed is not there. That question did not raise. It's only first time that is introduced. It's unnecessary also, because every case where there is a transfer, Registration Act is said to be there. That's unnecessary word, but they have used it. But that's now creating confusion. Yeah,
Thank you.
Yes, Shalini garu, please ask your question.
Good evening, sir.
Good evening.
Sir, section 25, 26, 28. Okay,
Yeah.
sir, chapter
Section 25,
26, 28, sir.
25, 26. You have a book before you? This is, this is also an important thing.
Yes, sir.
Very, very important. Actually, I have forgotten about this. Section 25, murder is disqualified. Murder. Many times what happens? People with evil intention, with evil mind, in order to succeed the property, they commit murders. Short term, just like short term measures, like quick buck, to make quick buck in the market. They do all sorts of mischiefs, bank cheats, cheats. This is also one cheat. But whether this type of people should be, the law is very clear. They said murderers who are convicted, awaits commission of murder shall be disqualified. Is not even convicted. Committed. Is commits murder. Commits means some sort of, maybe a conviction. It's not used the word conviction. But if an allegation is made a person that he has murdered, maybe court will have to go into whether that is a genuine thing or not. Section 25, it disqualifies them from succeeding the property. Claiming any property in the either ancestral or either a separate property also. And section 26 converts descendants disqualified. This is also another important area. Why this was introduced? It was deliberately done, maybe, perhaps, legislatively. They wanted to. This is only Hindu law. They are all separate unless a uniform civil code, uniform succession act in respect of properties, like uniform civil code, maybe that's all under the directive principles of state policy. We have got a provision already incorporated in 1950s at that time, saying that there should be, as far as possible, endeavor to make a uniform civil code a reality, because there are so many multicultural, multilingual, multi-religious, separate, it's hindering the development of our country. Because uniformity in these type of things will mitigate the litigation and increase the sort of economic activity by purchase or sale, whichever is advantage, whichever is disadvantage, they want to make some other way. These are all things which are necessary for nowadays economy. But this was made because as long as other personal laws are amended, not amended, and this is also incorporated. Maybe, but perhaps I can only visualize why that converts will not be disqualified. Means, suppose let us take a person who is SC community, he converts into Christian community, Christian religion, adopts Christian religion, then he will be disqualified. A children born out of that also will be disqualified. Because then he will get the right into the Christian Marriage Act or General Succession Act, Indian Succession Act. Then he will have to work out his remedies under that. This is religion-based law. Hindu religion is the basis for this law. This should be changed. Maybe that is what they wanted to uniform civil code. That's not reality. Therefore, as long as this is there, Section 25 will be there. There is nothing wrong in it, because the other person who wants not to practice Hindu religion and yet want to benefits of this may not be there. Succession, when heir disqualified, if the disqualify inheriting the property and this shall be devolved with such property as that before remains. As if Section 27 is nothing but same thing. If a person, as if he is dead, but his property is concerned not to other persons who is practicing religion. Suppose persons who have not renounced the religion and continue, but persons who are born after this conversion, then he will be treated as that community. It's natural, unless he renounces and come back to it. Just what is the process of renouncing, what is the process of accepting this, all is a separate thing. So this section 25, 26, 27 is nothing but to preserve the benefits of this law to the people who are practicing Hindu religion.
28, sir.
28. This will not disqualify, because people who are, suppose, let us say, a person who is born either defectively or there is mentally unsound mind, he needs a guardian, he needs a state as well as any one of his relatives as the court-appointed guardian or otherwise a natural guardian. But does he cease to have the right? No, he says they still have the right. But who has to manage that property? Maybe again guardian. But by virtue of a defect or what's called defect, disease or defect will not disqualify. But it's only change of religion, that is conversion or murder. Other people, but defect or disease will not disqualify. Either co-personal property, otherwise separate property also. Or under section 8 or under section 6 or under section 15. Am I okay?
Thank you, sir. Thank you, sir.
I request Mr. Rajeshwara garu to give a vote of thanks for discussion.
Yeah.
Mr. Rajeshwara, sir.
Sir, good evening, sir.
Yeah, thank you.
We, on behalf of ILPA, we are grateful to you for giving wonderful lecture.
Yeah.
Starting from the basics.
Yeah.
What is law and how the law is evolving.
Yeah.
Depending upon the changes in the society, not only our country, and throughout the world, and also you have started with Aryavartana and how it has changed to in the British rule, what are all the changes and now present India, and moreover in between what led to the changes in these laws, whether it is industrial revolution, economic growth, and finally human welfare has been considered on point, and moreover the women who were neglected by the religions, different religions, have been how they are protected, how it is development taken place. You have given us a wonderful lecture. So finally your advice to advocates, it is not their philosophy or their views and all. It should be the general will. That is general will of the people is now existing law. They should be abide by the law, and the welfare of the people is a priority, and we must go by general will and through the available laws. That message is excellent. You have given a lot of emphasis for this history, how the development of the law taken place, and your suggestion to go through this background. The history of the law is very important to upcoming advocates and all, because if they know the basis from where the roots, where the different ideas have formed and specific action has been initiated. So we are really great on behalf of ILPA and the participants. We express our gratitude. We thank you very much, sir. We are really enlightened by your talk. Generally, people think Hindu laws and Hindu acts and all, they are boring and they are somewhat confusing. But really, we enjoyed, we understood this message. We are all grateful to you. Thank you very much. Thank you, Mr. Samson Garu, and thank you, participants, and thank you, sir.
Thank you very much.
Thank you, sir.
Knowledge.
Lakshma Reddy, sir. Really, we are enlightened, sir.
Thank you very much.
Thank you, sir.
Thank you all. With this, I will conclude this meeting for today.
Yeah.
Thank you, sir.
Thank you very much.